Hey everybody, welcome to Rock, Paper, Hand Grenades. I am Matt Connerton, and hey, you're not Phil.
No.
Oh, Gary's back.
Matt!
I don't know if you saw the show with Phil.
Yeah, I saw it.
The Honorable Gary S. Hopper.
Hey, I fixed something. I was really kind of upset because I noticed that it's actually rock, paper, hand grenades.
Right.
And for the first year or so, we only had one hand grenade.
You're right.
It's plural.
Yes.
So now we're all set. We're good.
I got to remember to
We
bring
got the
a rock and some
kinder
paper.
we got the inhumane hand grenade and the kinder, gentler hand grenade from Vietnam.
That's good. This one is inhumane because some people are allergic to pineapples, correct?
I guess.
That's what it said on Wikipedia,
It did?
so I just assumed it's
Well, it
it's
has
right.
to be true if Wikipedia says it.
Yeah,
It's probably
absolutely.
true,
Yeah. It's on the internet.
Anyway, so what the hell's going on? What is cotton picking weird crap's going on the internet? You hear about the? Oh, let me introduce my guest first tonight. People in the legislature. You know, you're probably wondering who's pulling the strings in the legislature. Well, we have the three of the strings that are actually being pulled.
Oh my. All right.
All the way to my left is Paul Ingridson. He's chairman of the Committee of Redress. Next to him is, in the middle, the rose between two thorns, as they say, is Paul Mursky. I don't know, are you a chairman of a committee right now?
Until November 6th, anyway.
Yeah, for what committee, though? I don't even know.
Legislative administration
Okay,
and
okay.
Redistricting.
Okay, that's right. I forgot. And Dan Itza is the chairman of the Committee of Constitutional and something.
Constitutional review and statutory recodification.
Exactly what he said.
Yes, that's a mouthful and a half. Wow.
I learned to say it after a year.
Really? Yeah. That's
It
good.
took a year.
You must be tempted to abbreviate it sometimes.
No.
CSRS.
There you go. There you go.
CSRS, yeah.
Perfect. I can remember that.
I,
CSR.
I'm sorry, I did it wrong. Actually, it's CRSR.
Oh,
Okay.
CRSR. Okay.
4 letters, I couldn't get them straight.
So some weird stuff's going on in the news. Let's see. Facebook pulled. There's a.
Oh, I saw that story today.
Yeah, a group of Navy SEALs was posted some stuff on. The fact that the Navy SEALs were there for Obama when Obama needed them to take out Osama bin Laden, and yet the president wasn't there when they needed help in Benghazi. And Facebook actually pulled the group off the Facebook until they got so much protest they got it back on. So Facebook is actually conspiring to protect the commanderless in chief. Which is very interesting.
Yes.
I think it's very interesting because there's so much crap going on right now with the Benghazi stuff. And for those people who don't know, what fundamentally has happened, and there's more allegations out there, but I think they're just allegations, so I'm not going to repeat them. But fundamentally, in Benghazi, you had
Oh, we have a call already.
a call.
Wow. Should we grab it and then come back to this?
Right.
Hi, welcome to Rock, Paper, Hand Grenades. Who's on the line?
This is Ross.
Hello, Ross.
Ross?
Is this Ross Terrio?
Yes, sir. Is this Matt and Gary?
Yes.
Oh, come on, man. I deliberately
I need
don't
you guys
invite
to be
you on
useful.
here.
I need you guys to be useful and put a good word in for me. I'm running not only for state rep, but I'm also running for the Charter Commission, okay?
Oh,
Hey,
wow.
Ross, if your wife had
So
won, if your wife had won the primary, I'd put in a good word for her. But I don't know about you.
So if you do nothing else, your whole show, make sure you advertise my run for Charter Commission.
Charter what?
Commission.
What's your name again? All right, thanks.
Anyways,
Yeah.
have a happy Halloween, and I hope Matt hurry up and gets a job because I see him all the time, 24 hours a day on Manchester TV.
Living on the dole. You know how it is.
Yep.
Yeah.
I'm one of the 47%.
Exactly.
So, did your wife take her defeat in the primary? Okay.
Oh, she took it excellent because she did absolutely nothing. No name recognition. She got 100 votes. She didn't think she was going to get any.
Oh, well, that's good. That's definitely a glass half full scenario.
All right. Well, good luck to you, Ross. In spite of the fact I don't like you.
Yeah. I don't like you either.
Hey, thanks, brother.
Later, bye.
All right.
Bye.
Bye, Ross. Oh, that was a surprise.
Yeah, it was. So anyway, in Benghazi, there was multiple requests for added security. The administration basically decided to rely on local security, which was null and void pretty much. They had the attack, and then the administration blamed the attack on a spontaneous, the result of a spontaneous protest
Oh, okay, yeah.
over some stupid
The
YouTube
movie.
video.
Yeah.
That also was not true. They had real-time video and knew that it was actually a planned attack, an orchestrated attack. And so there's a lot of evidence or a lot of emails going back and forth and stuff leaking out that basically you had the annex and you had the embassy. The embassy was calling out for help. Nobody would help them. The 2 Navy SEALs in the annex were told to stand down. Finally, they conceded, disobeyed a direct order and went and helped them anyway and got at least 20 or so people out of there. Mm-hmm. And they ended up dying on the roof from mortar attacks. It was like a 7 or some odd hour fight, and the Obama administration sat back and let it happen. And that's what's kind of coming out in the news and some other crap. But it's amazingly profound that our commander-in-chief would let people die like that. But that's the big news.
Should we grab this call?
Yeah,
We have another
sure,
caller on
sure.
hold. It's a busy day this
I know,
week.
we get like one call a month.
Hi, welcome to Rock, Paper, Hand Grenades. Who's on the line?
I like that.
Hello?
guy. A lot nicer.
Oh, hey, I'm not running for anything, but I thought I'd give you a call and say happy Halloween. Have a good show.
Thank you.
All right, thanks, Eric. Bye-bye. That's Eric, frequent caller to
Anyway.
all the shows.
Earlier this week, Paul, the not as good Paul, called me earlier this week and said
Wait, which Paul? I don't know these guys that well, so I don't know who's who.
the not as good one.
Who's
It's a little guy.
This is Paul and my other brother Paul.
Your other brother.
Is it this Paul?
There's Dan Paul and his
be.
other brother Paul.
Maybe
Okay,
not.
but which
Not so
Paul's
good.
not as good? Is
No,
he
not
not
so
as good
good.
because
No, I'm not as good.
he has less
No,
beard?
he's
He's
the
got
good
better-
Paul.
He's got a better beard.
He's got
Oh,
more.
okay.
Yeah, Paul, yeah.
Okay, so he's less good. The one with the bigger
Oh,
beard.
yeah.
Yes.
Yeah.
Do you have beard envy? Why is he less good?
Because I
Yeah.
know I know
Why is
him
he less
better.
good?
Oh, okay. Well, fair enough. All right.
Anyway, Paul Ingerton called me earlier this week and wanted to use this show to talk about Question 2 on the ballot, which I'm going to let them talk about it because, I'm as ignorant as the day is long, so.
Well, we should tell you what question 2 is, and then you can go from there. I think that'd be the best thing to do. The memory man, Dan Itzer, will tell you question 2.
Wait, I just want to preface this by saying you do have to question the integrity or common sense of anybody that would call me and ask to be on my show.
Yes, you do. Yeah.
We're learning
Well,
that.
Ross Terrio came on and then blamed you for because he
when
lost.
he lost. Yeah, I know. He lost.
Of course, you did repeatedly refer to him as a drug dealer because he's a pharmacist.
That's a drug dealer.
Well, I know.
Pharmacist, drug dealer.
I'm just saying, you told the truth and he lost.
I know.
That's all.
So-
That's all I'm
Oh,
saying.
man.
Sorry, Ross, we're just kidding. Anyway,
So, question 2. Question 2 is a question to the people as to whether or not they want to
I
amend
think
the
you have to be a little closer to the mic,
Sorry.
Dan.
How's that? Question 2 is a question to the people as to whether or not they want to amend the Constitution of New Hampshire, Part 2, Article 73A. Right now, Part 2, Article 73A reads, and I should have had this open already,
Yeah, you
but
should
look
have.
how fast I can get there.
This is a wicked
The
important show.
Chief
I don't know if you
Justice
guys know
of the
that.
Supreme Court shall be the administrative head of all the courts. He shall, with the concurrence of a majority of the Supreme Court justices, make rules governing the administration of all courts in the state and the practice and procedure to be followed in all such courts. Rules so promulgated shall have the force and effect of law. The question is whether or not the people want to add to that the legislature shall have concurrent jurisdiction to make court rules, and I'm going to have to paraphrase here because I don't know it verbatim, that if there's a conflict between the court promulgated rules and statute, that statute wins, provided that it's not contrary to other articles of the Constitution.
my head hurts. What does all that mean?
It means that we are restoring or recognizing the legislature's authority to govern the practice and procedure in the courts. It's something that
Oh, okay.
that if you go back to the beginnings of the state or as a colony, the courts had the power to make rules for governing what happened in the courtrooms under the authority and supervision of the king.
What he means, like rules like as and when they're going to meet, what are the rules of evidence and things like that.
Okay.
Right.
To run, basically, rules to run the
to,
court
to
itself.
process the cases.
Yes.
And with the enactment of our Constitution, that power was transferred to the legislature. We know this because in 1791, the legislature passed a law allowing the courts to make rules for the processing of cases. And if the courts had already had that, the legislature would not have had to make a law giving it to them. However, the legislature did keep in its own hands things like rules of evidence, how much attorneys were going to get paid, and the like.
Really?
Yeah.
So they were communists.
No, they just knew lawyers.
Sorry. This gets worse, so keep going.
Well, it would,
Dense, isn't it?
Yeah.
I mean, am I doing a monologue here? Or?
Let's try this. Let's put it this way. From the beginning, this is a state in which all the power was given to the legislature in our Constitution. No matter what anybody says about three equal branches of government, that's just not true.
Not in New Hampshire.
No. If you read the Constitution, you'll be amazed to learn that the principal power is the legislature, the weakest power is the governor, and the judiciary does not exist as a judiciary as in the way we think about it today. We really create a bunch of judgeships, and they're sent out on horses to basically figure out what to do about cases having to do with justice. Now, as Dan often says, that the state was formed in its primary purpose is to provide justice. So this is not a small thing. And the fact that the founders didn't create a huge judicial behemoth to conduct these affairs tells you something about where they thought justice really lied, and it's in the capacity of judges to sort these issues out. And so for 194 years, I think it is 196 years, something like that, we operate in New Hampshire with a judiciary which is fundamentally under the jurisdiction of the legislature and to some degree the executive. I mean, the executive appoints judges, the council confirms judges' appointments and all that sort of stuff. The legislature may weigh in. But for the apparatus, the rulemaking, the structure of the court, the funding of the courts, all of that was subject really to legislative decision-making.
Yeah, I think there was a point in time where the legislature could actually, or has, disbanded the judiciary.
Yeah, Dan knows the dates, but it says like 5 different times, 3 of them in the late 19th century, and then 2 early in the century. Anyway, the point is,
Well, the reason I bring that up is because if they were truly co-equal branches of government, the legislature would have never had the authority to disband them.
exactly.
Until 1964, the legislature had authority to create and disband all of the courts. In 1964, there was an amendment, Article 72A, in which the people created 2 constitutional courts, the Supreme and Superior Courts, that the legislature could no longer disband.
We want to go back, and one of the things to think about, we're talking about disbanding the courts. In the late 19th century, when it happens 3 times, Republicans get elected, the courts get dissolved, Democrats get elected, the courts get dissolved, no judges are appointed, Democrats or whoever the other party gets elected, it happens again. I think, beginning in the 19th century, what happened was the court, the judiciary, members of the bar, if there was a bar even at that point, began to chafe under this idea that the legislature could take the courts apart. But you can't have free government without public oversight. So if that's what if the legislature thought the courts weren't functioning, then it would be their charge as representatives of the people to take the courts apart, put them back together in some other way.
So what would they appoint? A new batch of judges?
The governor would have the option to appoint a whole new bunch of
Oh,
folks.
okay.
And there is a provision in the Constitution which provides for taking these individuals who are appointed essentially subject to good behavior, essentially for life, judges. The provision, the way that they would remove someone was by address, a bill of address. So if you had a half a dozen judges, you'd disband a court, there's 10, 15, 20 judges, you'd remove them from their positions by bill of address. It's a simple administrative way of removing a judge. It's not an impeachment. You no longer have the court, so why would you be paying these guys
Right.
as judges? So that device exists within the Constitution as a way of removing administrative offices. So as someone just pointed out, if the courts were truly as independent as the justices would like you to believe, the legislature would never have had the power to do any of this.
Yeah.
Right? So, and that's an important point. Anyway, over a period of time, I'm sure that the judges began to think, people in the judiciary began to think about how to get the legislature off their back, how to prevent the legislature from removing judges, how to keep them from interfering if they felt the courts weren't doing a good job. And if you start to look at the Constitution and the amendments to to Part 2 of the judicial, the part that addresses the judiciary, you find a series of amendments beginning in the mid-50s, which begin to modify the capacity of the legislature to affect judicial decisions. First, they do some name changes. Next thing they do is they do something with making the Superior and the Supreme Court constitutional courts, so you can't disband them anymore. And then they adopt an amendment. They propose, and we wind up adopting an amendment which essentially gives the courts full administrative authority over all 10 courts in 10 counties.
All right.
And
Paul?
that, in turn, the judiciary then takes that language and, on its own, essentially creates this myth that the judiciary is entirely independent. They use language from the Constitution improperly to do that. And over the last 30 years, they've created this idea that somehow these courts were always, as a third branch of government, is totally autonomous. It's not subject to any legislative review whatsoever, and it's become an entity unto itself. And
Okay.
it's caused all kinds of troubles. And we're
Okay,
trying to fix
we're
it.
going to stop there for a second, take a
We'll
call.
grab this call. Hi, welcome to Rock, Paper, Hand Grenades. Who's on the line?
Good one. Yeah, perfect.
Did they hang up on us?
It might.
We're right here.
Oh, there we go.
What's up?
Hi, how are you? My question is, how do these amendments to the Constitution and the Bill of Rights affect the oath of office that they take?
Oh,
Any judge, any peace officer, any of these people who are supposed to be protecting the citizens?
how does it affect them?
Yes.
Oh, how does question 2, if it's enacted, you mean? How does that affect the oath?
Yes.
Okay.
Oh, well, before that, the thing I was going to make a point about is the courts have been doing a fascinating thing, and this brings us to a lot of where we are today. What they do is they interpret the Constitution to mean something brand new, and the Claremont decisions are classic cases, and they change the meaning of the Constitution by interpretation. That is an act that is an act of treason in a constitutional form of
Well,
government.
he's asking.
I understand that.
Right,
This
yeah.
this is a preface to that.
I know. I'm getting there.
All you have to do is repeat the oath of office that any judge or police officer has to take, and then what he's explaining will make sense.
Yeah.
Right, sure.
But why don't you continue,
What else?
continue with that thought, though, as you said, aggregating the authority, deciding for themselves, essentially becoming the new definer of a new constitution through judicial fiat.
Right, and obviously, and the downside of this is, where does that leave the people? So these guys, by interpretation, change the meaning of the Constitution. The Claremont decision is a classic case, 200 years of history. And where does that leave we, the people? Where does it leave the legislature? Now we've got to go through this enormous process where we've got to get 60% in the House and Senate, which is tough enough by itself. Then we've got to get out on the street and get the rest of the House. And all we're trying to do is bring back a Constitution that isn't saying that in the first place. So this is what I express as the most fundamental dilemma that we're dealing with overall.
It's important to understand the backdrop here.
Wait.
When anybody tries to change the Constitution, they are bucking their oath of office.
Absolutely right.
Absolutely.
So
It's that simple.
in other words, I think what the caller's getting at, if you have a judge, like in the Claremont decision, that is obviously violating their oath of office because they're sworn to uphold the Constitution, but they're rewriting the Constitution, so
Giving
they're
new
not
meaning to it.
upholding, they're
Right.
actually writing law, which is unconstitutional for the judiciary to do anyway. What's the repercussions for that? Because it happens frequently.
They're actually going a step further than writing law. They're actually writing the Constitution. So I want to
Okay, yeah.
point
it's
out
a
the
step.
backdrop.
If they rewrite the Constitution, they are not upholding their oath of office
That's correct.
in any way.
That's correct.
So what is the consequence of that?
It depends on the how much backbone the legislature has.
Yes, exactly.
I mean that's and how incited the people are when their restraints on government are violated by the judiciary. If the people don't push for their legislators to impeach the judges, the legislators are not going to have the will to impeach the judges. I mean, it's hard enough when you have something that is extremely clear cut, like the Brock impeachment, which they were impeached by the House, but they were not convicted by the Senate by one vote.
I don't like the word convicted. They were not removed from office by the Senate. They were essentially convicted in the House. They were not removed from office by the Senate.
It's funny to me that Bill Clinton can possibly be impeached by having a sexual situation go on, but when the President of the United States is trying to amend or rewrite the Constitution and ditching his oath of office, he can turn around and not be impeached. That is ridiculous.
Wait a minute. We're talking about New Hampshire as a different issue.
We're getting into a different.
Yeah.
New Hampshire falls right into it because the legislation is trying to change things
Well, let's
against the Constitution.
not
That's not correct.
All right,
not
we're gonna
legislation and not
continue on with-
legislature. No, let me,
Well, I'm gonna let him go. 'Cause
okay.
We can,
yeah, we're gonna let you go because we got to continue talking about question 2, or we'll,
Right.
we'll
I
run out
want to
of
give a
time.
little
All right.
backdrop
Thanks,
to
caller.
this.
Thank you.
In 1964, there's a constitutional convention. At this time, the 10 individual superior courts are proposing rules to the Supreme Court for the Supreme Court to approve. That's the way things had been done by custom for quite some time, unless the people were upset with the court rules, in which case the legislature would step in and provide a statute that provided court rules. This led to a condition where the court rules in each individual county were slightly different. And so the purpose of Article 73A was to provide uniformity of court rules among all the courts. And in that convention, there was actually a debate in which Representative Gross asked, will this deprive the legislature of any of its current right to regulate the practice and procedure of the courts? And Delegate Niswander replied with, no, as far as I can see, they will have every power they currently enjoy. So Article 73A was never intended or designed to take away any power from the legislature.
Oh, and by the way, Gross and Niswander were the two of the most prominent attorneys in the state of New Hampshire at the time. Highly regarded by members of the bar. These are not individuals that are out there just simply making stuff up.
Now, despite this real defined statement that it took no power away from the legislature, over the next 30 years, the judiciary has repeatedly interpreted Article 73A to say that the legislature can have nothing to do with making rules for the court. In, I think it was 95, we passed a law saying that judges who had been suspended by the Supreme Court weren't going to get paid. And they said we couldn't do that. In 2000, after the Brock impeachment, instigated by a friend of mine,
The good Paul.
Oh, the good Paul.
the
Yes,
good
yes.
Paul, we
Rose.
created a legislative judicial conduct committee. And pursuant to Article 73A, they said that we didn't have that power because we would be creating a standard of judicial conduct. So they have
Lord
just...
forbid we should have one of those.
So,
Well, the Constitution says subject to good behavior, and it's our judgment as to whether or not they're behaving properly.
Right. That makes
and
sense.
who
yeah.
removes them when they're not behaving well?
One of the
We do.
clearest things we've run into is the court has no management of itself. It doesn't remove anybody, doesn't have the power to do it, and it doesn't do it. It doesn't manage it, and yet they don't want us. They've actually told us we don't have the power to create a review committee. It's one of the more remarkable things. But I think probably one of the other things that we're talking about before was that we have to deliver, and we don't have to stay on this one because it's a little bit of an aside, but they have already, another thing they've already done for themselves is they've decided that they are the ones who determine the meaning of the Constitution and not the people. And this is easily one of the more remarkable things for a Constitution written for and by and signed on to by the actual people themselves, that these guys can now interpret it into some other meaning, and they have the last say regarding this. But that's the last piece on that. Okay, yeah.
No, and that's extremely important because the Constitution itself says in Article 37, Part 1, that it is the people who have the say in enforcing the Constitution upon all the lawgivers, legislators, and magistrates.
Yes.
So it clearly gives that final jurisdiction to the people, And it doesn't give that jurisdiction anywhere
To
to the
court.
courts. The lawyers will tell you that Article 35 says, well, they're supposed to interpret the law, so they must be interpreting the Constitution, which is the supreme law of the land. Well, that word law, which appears in Article 35, every other place, I think it's 23 times in Part 1 and 26 times in Part 2 or something like that. Every other place, either explicitly or implicitly, is referring to laws
Created.
passed by the legislature pursuant to the Constitution.
Statutes.
Nowhere does it refer to the Constitution itself. And yet in that one article, not likely, especially when later in that same article, talking about term of office, it refers to the Constitution. When they said Constitution, they meant Constitution. When they said laws, they
You're
meant
talking
laws.
RSAs, what we call RSAs.
Yes.
I refer to them as cowboys. I mean, I think that's what they are. There's 5 unelected guys, 3 of which can change the meaning of our Constitution, and they will do it. The conversation about their motives is a fascinating one. This question of the politicization of the process, they're claiming that we don't have the powers that we're talking about here. We don't have the right to oversee the courts because we have a political side. We'll politicize it. But
Well,
who's,
let-
who are the ones politicizing the process? Anyway, yeah.
Let's put this kind of in a context. This 73A, Article 73A, which has caused all this the opportunity for the court to run away with the judiciary in a sense. That capturing of the judiciary was really occurs between 1978 and probably sometime within the last 5 years. We have a court right now that's sitting, which I think has somewhat different perspective, or perhaps would wish the situation was somewhat different. In that, previous to this, the Chief Justice, Justice Brock, certainly the last Chief Justice, Justice Broderick, completely acting as Representative Ingridson has said, in a way which really has attempted to distance the court from the legislative process and to create this new entity, which is an autonomous court, unreviewable by the public. The current court, though, I think, has looked at the past history, the impeachment of the Chief Justice, the bunch of corruption cases against judges back in the late 90s, mid-90s, late 90s that occurred, other problems having to do with now currently the family courts, which these 2 guys are really experts on the subject, and particularly Representative Ingridson at the present. These difficulties that they're currently having within their own system that are giving them a bad name, the current justices, I think, came to their senses in the last session. I filed a bill essentially to repeal 73A to get us back to where we were prior to 1978, so that there would be no question as to how the mechanics of the system would work in relation to public oversight. But the judges came back and they offered amendment language, which essentially ceded back to the government, to the legislature rather, the opportunity to interface on these laws and rules, and Dan can speak more specifically to that. But so the justices came back with language, which I thought was actually pretty good. It's better than other language that was proposed in the past, and I thought that it was a good faith move on their part to say, look, we have this terrible relationship between the legislature and ourselves. We're not doing real well necessarily we could maybe not be doing very well with the next governor either. Maybe we ought to look at this. We ought to try and find some way to tamp down this friction that's occurring between the 2 branches, because the legislature is claiming we're acting improperly, or we're not paying attention to our own rules. And so they've given us this language, which is on the ballot. The justices themselves wrote the language. The Chief Justice, in concurrence with the other 4 members of the court, wrote the language that's being proposed on the ballot. And I accept that as a court reformer. I think it's good language. Others have accepted it. The legislature obviously accepted it, both the House and the Senate, and that's what's on the ballot. And what we have going on outside this room is an interesting display from other members of the bar. I think sycophants of the last group of judges who really wanted to aggregate this power. They're out there trying to kill this amendment that their own justices on the court created.
That's an interesting dynamic.
It's a very interesting dynamic. So for the first time, we have an opportunity to kind of ameliorate this enormous difficulty that's been occurring since 1978. And we have members of the bar and certain retired justices, including the last Chief Justice, who I think like the aggregation of power, and they're trying to kill this amendment. And so it's an interesting dynamic.
And the other side of that is that the Supreme Court, all 5, have concurred that it's the right thing to do. They agreed on the language
Yeah.
before it came before us. So that's their language in this question too. It needs to be supported. We need to vote yes on this, and it gets back the courts so that we actually have a bit of oversight, so it doesn't become an impeachment problem every time something turns around and we look like we're this vicious bunch of people trying to attack individuals. It's a wrong way to approach it. We just simply should have oversight over rules, especially when they go wrong, and then who gets hurt? It's the people. And if they get hurt by unelected characters, and then there's no elected people, no representatives who could be thrown out of office in 2 years, what does happen?
And I know we've had a lot of problem with this on specifically on the family court, where you've got judges and marital masters that are just toasting people and toasting and it's one thing we see the adults come up saying the things that have happened to them, and you kind of feel bad for them. But the ones that really bother me are the kids, because they're the ones who are really getting nailed because they don't even understand what's going on. Right. We've got like tons of fathers walking around the legislature that haven't even been able to see their kids for years because of some crappy judge. Last term, I introduced legislation to take Representative Mirsky's earlier bill from 10 years ago and make it constitutional, so that we would have a constitutionally provided for judicial conduct committee. Mm-hmm. But leadership didn't want to have more than a couple bills out there, constitutional amendments, so it didn't go anywhere. But it's been it's been a problem ever since I was first elected.
I think Representative Ingerson ought to talk about the redress situation, particularly as it relates to family. Because one of the things he said in the course of one of these presentations we made a couple of weeks ago that stuck with me, and it is that if you stop and think about it, given the divorce rate, the place where most people come in contact with the courts now are family courts.
Yeah.
That's where the majority of individuals in America have a relationship with their courts. And in New Hampshire, we have a lot of difficulty there. And I think we could talk about this, and we could talk about their rulemaking, how it's enforced, and how this amendment would give us an opportunity to perhaps correct some of the great difficulties that they're having.
I mean, before you start,
go ahead,
I just want to remind people that our Constitution says that all the power in government originates in and is derived from the people. So it's the people's power. And how absurd is it that if the people see their power being misused, particularly against them, that they have absolutely no mechanism to correct the use of their own power.
Right. This is no accountability.
It's back to that same question.
Yeah.
So the interesting thing we found, I mean, first of all, in 27 petitions for redress of grievances, about half of them were out of the family division.
Well, back up. What is a redress of grievance?
Okay, the
Where
redress
does
of
it
grievance.
come from?
Yeah, thanks for asking that. It's a very important point. You know, Articles 31
You can
and
buy
2.
me an iced tea or something afterwards to make up for it.
I was hoping
You've
for
always got an angle.
Yeah, that's actually a more readable one. Yeah.
Yes.
Thank you. Yeah.
Cheap date.
Oh, yeah.
So Article 31, the legislature shall assemble for the redress of public grievances. It's right up front. The legislature is given an order. They shall do it. This is a right of the people. It's under the right section. The legislature shall assemble for the redress of public grievances. And, by the way, for making such laws as the public good may require. So they're not to be confused. Redress of public grievances is one thing, and the passing of laws is a different thing. And so they've tried to confute that in the last few years and say, oh, you always come up, everything we got is a petition, because laws were always promoted, statutes were always created by petition. But these are two separate concepts. One's to make laws, one's redress. Now, listen to the next part. This is the more crucial one, the more powerful one. That's the people, and this is Article 32. The people have a right in an orderly and peaceable manner to assemble and consult upon the common good, give instructions to their representatives, and to request of the legislative body, by way of petition or remonstrance, redress of the wrongs done them and of the grievances they suffer. And therefore, we didn't create it, but we had these petitions coming before us. We asked in the Democrat legislature, we asked for a redress of grievance committee. We asked for anything where they would at least take them into a regular committee and listen to them. And they wouldn't do it. We instead had to go to a private caucus and begin to listen, to begin to see what these people were seeing, because we took it as our duty, constitutionally, as per these statements here, to go in and do that. We heard what they were. The people in the next term brought in, well, in that term they brought in petitions, but they had no way of actually bringing them in because there was no legislative act, no process. So the legislative services said, we can't do this. We don't have a way. There's nothing written anywhere. We don't, because it's been so long. It'd been 50 years or more.
Can I interrupt you a second?
Yeah.
Yeah, so 2 years, 4 years ago, under the Democrats, we tried to have a committee. It didn't quite work out. I was still working full time there, so I was kind of in and out of that committee once in a while. Or you can't call it.
came and
It
listened,
wasn't
yeah.
even called a committee. Caucus. The one cool thing about the radical right-wing takeover of the New Hampshire legislature is the fact that we were able to create a committee so that at least people, it's not quite what the Constitution says, but at least people have a method. If they have a grievance with a judge, if they have a grievance with a town, or if they've been believe that they are been treated badly by the judiciary or by their town,
By government.
they have a vehicle to go to the legislature and hear their grievances, and hopefully as time goes on we'll get better at resolving those grievances. But that's what Paul's talking
Yeah,
about.
and we should really always, every time this comes up, we should give credit to the Speaker, Bill O'Brien, because no other speaker that I know of would have had the guts, or even thought it even possible to do something like this.
Yeah.
It's really quite a crucial thing to recognize what he's done for the people here, to at least say, let's open this door. In the previous administration, they say under the Democrats and that speaker, they would simply take the petitions, read the title onto the floor, and put them in a file cabinet.
Really?
And we're told not to allow their committee chairman to pick any of those committees out of there and call the people in and listen to them. They were specifically told not to do it. And that's a long and short of that story. So we're in a marvelous place right now to have heard these things. But let's get to the gist of it that as it relates to this bill today. What we found is that due process was being denied across the board with certain marital masters, just like over and over and over, and judges. Judge Arnold being a notorious one, just like repeatedly, not follow basic rules like the GAL has to go in and ask for a hearing to increase the amount of a stipulation over $1,000. He got to 40.
Ad litem, is that GAL?
GAL, guardian ad litem, which is the way of theoretically protecting the kids. So he gets up to $40,000 without ever bringing, and we have the documents, without ever bringing a single hearing. And this person who's under this is being given a bill. At one point, he was sitting in a courtroom with a whole different process going on, and handed a bill by a guardian ad litem for $17,000 and told he was going to jail if he didn't pay it that day.
Wow.
I mean, this is kind of as unruly as a court can get.
Yeah.
And this is beginning to drag down the reputation of the courts, which is a most crucial piece of a justice system.
Well,
it
'cause
has to be credible.
The scenario you just described, it sounds like a big scam.
Well, I don't know what else you would call it.
Yeah.
But so it comes down to where's the management. So these
Yeah.
people will go and complain to the PCC or the whatever the professional conduct committee is, or to the judicial conduct committee or whatever it is, and nothing is going on. The courts don't take care of themselves.
No
they seem
accountability.
incapable of taking care of themselves, and why would they?
Right.
I mean, they are them.
Right.
They need oversight.
I want to give you one of the great things, the beginning of this term, when we had the impeachment of Marital Master Cross being heard. And we had several instances, one of which was that he was changing things in financial affidavits and parenting plans over people's signatures. So they had already signed the document, and then he was making changes to it.
Which is, we believe, a reason to impeach somebody.
Which is in fact a crime,
It's a crime.
of official falsification.
Yeah.
Okay, and sworn falsification. And at the conclusion, the administrator of that court, Judge Kelly, said to the Judicial Committee that they couldn't hold him accountable for that because they all do it.
Oh,
Now,
wow.
now, where are the people at a time like that? Wow. Where does that leave us? Never mind getting into the details of what we found in the family division itself. But the point of the family division is we found that we created a
That
lawsuit.
blows my mind.
Well, no, it's
really
worse
does.
than that because
Really?
he wasn't impeached.
Yeah.
Well,
He
that's
was not impeached.
right.
Well, no, there were legitimate reasons for that because he did not sit in an impeachable office.
Yeah,
I
whatever.
mean, so I
Or
mean,
an addressable office.
Something bad should have happened to him.
No, I know. I was the one who wrote the minority report because by that time I had misplaced my seat as chairman of Fish and Game, and I was
Misplaced, so like that.
I was over on Judiciary, and I saw that come down about Cross, and I had already been on the caucus the 2 years before, so I knew what was going on, and they were. That really bothered me. Even with that conservative a legislature, that guy still get off. Wow.
Well, but that was the
Should've been
oversight.
shot, but that's-
That should have been under the oversight of Judge Kelly, and we found since that he actually could have fired him. We know that he could have fired
really?
him. This is mismanagement on that level, if that's true. But the bottom line, though, where we are now is we found this interesting thing. We found that we created an equity court in which it says basically that any laws or rules to the contrary notwithstanding, the judge, will then come up with his version of justice, which totally subjectifies the entire process,
Well,
which
the
is the
whole
most
family
remarkable.
court doesn't even necessarily go by the same rules as the
Well,
regular court.
that's what we find. We
Well-
also find they have a rule 1.2 that says that they can waive any rules, so the whole thing becomes a joke. Now, no, but that's not the key to this. The key to this is we did this, we created it. The court didn't create this, we did. The question now is, if we decide to change these rules, what is the court going to say?
Right.
This is an equity court. This is ungodly. I mean, they got rid of them in this country mostly. Not equity in the
Not really. They got rid of
concept.
them in England, but an equity court, a court has equity jurisdiction given by the legislature
Right.
when there is no law to govern the particular case, and then the court's authorized to do what they judge to be best. That's why you have judges.
That's an element of equity in a court.
In a court, and so the Superior Court has equity jurisdiction when there's no statute governing the circumstance in a list of types of cases. Same thing for the probate court. District court has no equity jurisdiction. Family court jurisdiction says, law to the contrary notwithstanding, they have equity jurisdiction in a list of types of cases, which is all the cases they handle. Which means that it doesn't, law to the contrary notwithstanding means that any law that we pass, they are not beholden to.
Right.
Wow.
And this is when in the
And
face
that's
of
in
what we
statute. We did that. We created it.
Yeah.
Right.
Yeah.
But in the face of the fact that we used to write due process and tell them what it was,
Right.
now we're in a place like this. The question for me is still, would they then push back and say, no, we have the rule power, writing power, and not allow us to even change this kind of a court? I believe they wouldn't do that, but nevertheless, these are the kinds of questions that come up. We are looking at this now as a quandary, as a real crisis.
Yeah.
No, we have an ongoing constitutional crisis, but we haven't really addressed it very well.
What,
But
can't
I think
can't we just get guns?
No, well, look, I think what listeners, what your listeners ought to be thinking about is this: that government's all about power, right? We know it. That Washington's famous statement is that government is force. So we know that this is all about power, and if you give any entity or group of individuals an opportunity to expand their power, they're going to do it. Mm-hmm. And we did that in 1978. We gave them language, unintentionally gave them language, which allowed them to interpret what we'd given them in ways which was never intended, and they've run off with the institution. Now, what's the legislature's response? Well, the legislature, most legislators, are like most other people in society. They don't want to think about going before judges. Judges, for some odd reason, is that once a person is appointed a judge, for some reason they attain some kind of almost godlike stature, no matter who they are. Now, Justice Brock, Chief Justice, when I was first elected to the House, was no more than Governor Thompson's counsel. Justice Broderick didn't have any particular qualifications necessarily, except that he was Governor Merrill's law partner. We're not talking about people here who necessarily have distinguished
That's just a
themselves.
coincidence, right?
Interesting.
yeah,
Just a coincidence.
He actually appointed his own.
I believe.
Law partner?
I believe that. I don't want. I can't. I'm going to go. I don't want to say that. I'm not.
Okay.
I'm not absolutely certain.
But if it's true, that's
See,
pretty
he's
bad.
smarter than me.
No, I'm not certain. I'm not certain. But the truth is, it was his law partner. Now,
Yeah.
and people get appointed by governors because they have some relationship. Mm-hmm. It's not necessarily because they're great constitutional scholars. That doesn't mean the people on the court are necessarily incompetent.
Right.
But it's just a matter of saying they're average people. They put their pants on one foot at a time, like most of us, except Gary, who has no idea how he gets dressed. So, but most people, they're no different from any of us. And
How do you know that about Gary, by the way?
That's a really good guess.
Okay. I had to ask.
A really good guess. But anyway, so it's an odd transformation that happens. Odd transformation occurs, and so people suddenly
things I don't say.
see these folks as being untouchable.
Yeah.
The legislature's job is to step up and point out when, well, either branch, we're a check on either branch, right? The executive and the judiciary. It's our job to point out the deficiencies in either branch. And it's the job of the folks in the executive to point out the deficiencies in the judiciary
Yeah.
or the legislature.
It's the whole idea of checks and balances,
And it's
really.
the job of the justices to make certain that the legislature doesn't run off and create, I mean, in ways that, or at least all they have is moral suasion. All they can basically do is rule in a way that identifies a constitutional abrogation on the part of these other branches. They have no other power otherwise. Anyway, so our legislature, because of the nature that this influence the judiciary tends to have on people, the legislature has been very reluctant to call the justices over the years on their improper behavior. They hate the idea of doing it. And so as a consequence, that creates a huge vacuum. And I think the previous justices on the court took advantage of it. I'm not criticizing the current court. I'm just saying the previous courts, I think, did that. And so what you asked,
Do you think that is also probable? Okay, you probably won't answer this. I'll ask Dan. Dan,
Ask Dan, he'll answer anything.
do you think it's probable that the court is more compliant these last 2 years because the legislature moved so far to the right in the last election that they're slightly concerned, and maybe they will swing back to their belligerent stance if the election goes poorly next week?
I don't know that that's true. I think of Judge Lynn, who's testified before my committee. He has a long history, both as his current position as a Supreme Court justice and as a Superior Court justice, of being very friendly to the legislature. I would say remarkably so, given I came in 2000, so just on the heels of the Brock impeachment. I think there is, I think part of it is the Committee on Redress of Grievances, in which we have begun to get a real handle on what's happening in the judiciary. So we're lifting the hem of the judicial garment and looking underneath.
what
It's
I
not
would say.
necessarily a good picture.
Well, I mean, but we're seeing what's happening behind the curtain.
I would say.
I like that better than
Okay,
under
thank
their-
you.
Yeah.
I would.
But it's
yeah.
you're given this picture of people who can do no wrong.
Yeah.
Yet we know they're really only people, just like we are.
Except me.
But now all of a sudden, over the past 4 years, really, because between the caucus and now, we have begun to understand, particularly how they are operating. 4 years ago, we didn't know about Rule 1.2. Right. Just in the last few months, last few weeks, we learned, for instance, that the rule on evidence promulgated by the judiciary is verbatim a statute from 1941. So of course we had the power to make these rules. We're putting together the pieces of how things happened, and I think because we're seeing it and we're talking about it, they may be becoming aware of it too, and maybe not entirely comfortable with what's happened over the past 30 years.
I would rather say that I think Judge Lynn is friendly to the Constitution.
Yeah.
I don't think he's necessarily friendly to the legislature. I just think he's friendly to some fundamental ideas about
I would agree with that.
the Constitution. I think secondly, it's not a long fringe, but I've known Justice Hicks for a long time, although we don't socialize particularly. But in my relationships with him over the years, his law firm was a client of mine at one point. I always found him to be a very reasonable and straightforward kind of a person. I think Justice Delanis, Chief Justice, is trying to do some things to make the courts work better. I think she's been a constructive influence. So I'm not. I don't know that I don't think they're necessarily intimidated by the new legislature necessarily. I just think suddenly they have a legislature which was actually communicating with them in a way which they hadn't. It was more constructive maybe than in the past.
Well, I know that for the first 10 years I was up there, it seemed like we were basically sucking up to them. Every time we tried to do anything, there'd be the courts and some of the people in the legislature were so intertwined. Who was the Dan when we took the minority leader when we were freshmen?
I don't know. Idea.
Too far back.
Yeah,
I don't know what you're
Democrat from
referring to.
up near you.
Minority leader?
I think he was a minority leader,
Oh.
Democrat.
Oh,
Yeah.
Burling?
Berlin, yeah, Peter
Yeah.
Berlin.
Oh.
I think was he? He had some connection with the judiciary.
Oh, no, there are lots of associations.
Yeah.
New Hampshire's a small state, 1,300,000 people. People know each other.
And
A
we
lot
have-
of the stuff that was going on we're talking about was when the state was 600,000 people. That's just a small city.
Right. Anyway, we're running out of time, so fundamentally, question 2. Right now, the way the Constitution is, because of either foul play or a screw up, the court has the authority to write law, or rules that have the force and effect of law, which is a direct contradiction to anybody who understands anything about the Constitution as to what its place should be. So if you vote for question
Wait a
2,
minute. And secondly, they're claiming this. I've lost my train of thought quickly, but they're making an additional claim that we can't, and we have no oversight.
Right, but
And that's
anyway,
a
I know,
new.
but I'm
That's a
just trying
new
to
idea. No,
synthesize
those are
this.
two pieces for the. Both of them belong to question 2.
Okay.
Both of them belong there at once.
So,
It's
so
crucial.
if question 2 is passed, it goes a long way to restoring the original intent of the Constitution, where
Right.
the legislature has the authority to write laws, and the court has the obligation to abide by them.
Well, and consider that over the past 30 years, because of Article 73A and often resting upon it, the court has begun to claim what it calls inherent powers in rulemaking, whether it's the inherent power to punish contempt, which used to be a statute. If you believe that the power in government comes from the people,
Then vote for question 2.
then how can the court have inherent power? It can't. The power can't come from itself. If you believe it's your power, do you want to have control of that power through your elected representatives? Then vote yes on question 2.
Okay, so there's that. So vote yes on question 2, and vote for Ross Terrio for, what's he running against?
Was it
Dog catcher. I think it's a
Charter
dog
Commission?
catcher, wasn't it?
Charter Commission.
Charter
Ross
Commission.
Terrio is running for Charter Commission, and he's running for state rep again. He is a drug dealer, but that's okay.
Some
But a
people
legal one. A legal one.
Yeah, some people say
Still a drug
pharmacists,
dealer,
but
Dan.
But it's a legal.
he's
drug
still
dealer.
dispensing narcotics of some kind.
Exactly.
Right?
Yeah, absolutely.
But see, I keep calling him that because he won't dispense any to me.
Right, exactly. Well, I know how you feel.
It's upsetting.
I Facebooked him the other day. He didn't even answer me with my request.
I got glaucoma. He doesn't give me any medical marijuana.
Yeah. And I just, I was just feeling a little down. And
I know.
Ross,
We're helping him out in his campaign. He doesn't throw anything our way.
know.
if you
Maybe
know
he
what I'm
will
saying.
now.
But anyway,
I see the light.
hey, well, thank you very much, Paul, and Dan. Dan and your two brothers, Paul.
And thank you so much. We
And
appreciate
your
it.
beards.
These guys are great. They're Paul was head of the HRA or founder of the HRA with House Republican Alliance with Lee Quant and Tony Sultani. Correct? No.
No, they weren't founders, but they were chairs at the
Oh,
time.
chairs. Okay.
Co-chairs.
And then Dan and I came in 2000 as Frenchmen together. And then what 2002, right?
Yeah, I came in
2002,
Yeah,
Paul
yeah.
came in. These guys are just awesome. They're up there for the free food like me, but other than that, they're all right.
Good reason to send it.
Yeah.
And the high pay.
See you
yeah.
next
You
week.
forgot
Bye,
about that.
everybody.
Hey, remember to vote and vote often.